Good evening, everybody. 7 o'clock. Can you all hear me okay?
Yes.
Okay, perfect. Thank you. I'm going to get started. I try to get things done promptly. So thanks for joining me tonight. I'm sure that there'll be others that are going to come in, the latecomers. Let me just see here. Give me 1 second. I'll give it a couple more minutes. Hopefully everyone had the opportunity to go out and vote today.
Well, I'm not in New York, so I can't vote, brother.
You still could have voted. There's other ways that you could have made it happen.
Oh, you know what? You're right. I could have did that on the computer.
Yeah. But that's a conversation for another night. We could talk about voting right.
Yeah, man. Man, you know my mind be gone sometimes, man.
It's all good.
Old age catching up quick.
I'll let you speak for yourself on that one.
I'll just be quiet.
All right. Let me see. I'm gonna get started, okay? I'm sure that other people will join us. Let me see here. All right, here we go. So first and foremost, let's just go here. All right. So here's my little disclaimer here. This session may be recorded and shared online or in other mediums. If you prefer not to appear on camera, please turn off your video or log out and view the posted version later. By participating, you provide your explicit consent to being recorded. So I do plan on posting this later on. It won't be immediately after this is done. So if there's anything that you missed or you want to go back and review, you'll have the opportunity to do that and come back and look at it again later on. Okay. All right. So first and foremost, a little bit about myself. Most of you know me, and I think I know most of you. My name is Jason Bost. I am an attorney. I'm licensed in DC, in New Jersey, and in New York. I own Bost Legal Group, and I'm the managing partner at Bost Legal Group. We've got 3 offices in New York, 1 in Brooklyn, 1 in Rochester, and 1 in Caledonia. And we just opened our fourth office in Newark, New Jersey. So we're serving clients in the New Jersey area now as well. My contact information is on here, and I'll share that with you again afterwards, but each one of you should have already received an email from me with the invite for this event. So obviously, if you got my email, and inside of my email in the signatures, you'll find the rest of my contact information. My firm practices and handles a variety of issues. We deal with real estate matters, litigation. We also do landlord evictions and closings. We assist clients with business matters. So we represent a variety of clients and act as their general counsel for their businesses across the number of industries. We assist with formation of companies, and we work with nonprofits and churches. I also practiced in the entertainment industry many years before even becoming an attorney. I was involved with the entertainment industry for quite a long time. So that's another part of my practice. Most of what we do in entertainment is around representing artists with transactional contracts and negotiations, things of that nature. We also do family-based immigration as well. So our immigration practice has kind of been scaled back, but we do offer services for immigration also. Let me see here. Let me pause this for 1 second here. See if I can get this to open up again. I'm going to stop my share here for 1 second. Sorry. Technical difficulties. Go this way. There we go. All right, let's see. Tell me what you guys can see here. Are you looking at a screen that just says legal disclaimer, or are you looking at a bunch of different boxes?
I
I'm
see a few
seeing-
boxes.
You see a bunch of different boxes?
Mhm.
Yes.
All right. Here we
Mhm.
go. Let's try this one more time. Apologize. All right, well, I'm just gonna go back to this here. All right, we'll just do this. How about now?
Now it's just the one.
All right, good. I can't see my notes, but that's all right. So anyways, let me read this legal disclaimer to you all. I'm an attorney. I'm licensed in DC, New Jersey, and New York. However, this presentation is for educational and informational purposes only. Nothing discussed today should be interpreted as specific legal advice. Participation in this session does not create any attorney-client relationship with myself or with Bost Legal Group. So that's my legal spiel. I'm done with that. I'll move on. So let's talk about the purpose, why we're here today. So I do a lot of work in the surrogate courts and around estate litigation, as well as estate planning. That's a big part of what we do. It's not uncommon when I'm litigating, on behalf of a state or against an estate, that the individuals that are involved in the process are totally clueless about how things work. That's normal. I mean, most of us don't understand any of this until we're forced to deal with a situation where somebody that we know or that we love has passed away, or we start to think about maybe we have a health issue or something that forces us to think about these things. So I wanted to make sure that there was some kind of a base understanding that was available for everybody. And don't worry, most people don't understand this stuff. This is stuff that it's not going to be common knowledge. You're not really going to understand it unless you go through the process yourself. So one of the goals tonight is to just give you a base understanding of how things work, terminology, definitions, and kind of so you get a clearer picture of just the entire environment around estate planning and surrogate courts and the options that are out there that are available. One of the things that I've noticed, and a lot of this I think is cultural. Many cultures don't want to talk about death. They feel like if you talk about death, it's going to open death's door, and somehow death is magically going to come find you. Or if they don't talk about it, that it's not going to happen. This is a news flash for all of you. We're all going to die. It's inevitable. It's going to happen one day, sooner or later. Now, mind you, when we're gone, it's not going to matter to us what's going on with the rest of the world and our estate, but it will matter to the ones that we love and that are going to have to be there to clean up the mess. So the more that we understand and the more we prepare, the better off we are. When we're done with all this, I'm going to have a question and answer period. So if you have any questions as this is going on, if you can just write them down, make a note of it, and then I'll give you an opportunity to ask those questions once we're done. I'm going to try to give you a lot of information very quickly. Again, just to give you a general overview. So don't feel overwhelmed. If you don't understand something, if something wasn't clear, please point it out to me, and I'll come back and revisit it after we're done and I open up the Q&A session. Okay. All right. So I'm going to break this down into a couple of sections. The first section, I want to talk about some tools that are available for us while we're still alive, and that can be implemented while we're still alive, okay? So the first thing is something called a power of attorney, or a POA. Many people are familiar with this term. They've heard it, but you might not be totally confident with how it works and what the purpose is. So a power of attorney is going to appoint someone the right to be a fiduciary and act on your behalf while you're alive. So what is a fiduciary? Now that we're going to use these terms, a fiduciary is somebody that acts and has to put the interest of another above their own. Okay, so if you're assigned a fiduciary position, it's your job to make sure that whatever you're doing in the role of the fiduciary, first and foremost, is the trust or the principal or whoever appointed you to act on their behalf. All right, there's a duty, you have a duty of loyalty and a duty of care that always have to be followed first and foremost. So the duty of loyalty has to deal with what I just talked about, where you have to put their needs above your own needs. So you want to make sure that there's no conflicts of interest that exist. And no matter what, you're always thinking about the trust, or you're thinking about the principal first. It's got to be above yourself. And the duty of care just means that you have the skill set to take on a fiduciary responsibility. So you don't have to be an attorney, you don't have to be an accountant, but you do need to take the time to understand what all encompasses the what's being asked of you. Right. So the power of attorney is going to enable somebody to make financial decisions for you or on your behalf while you are still alive. Usually a power of attorney is going to come into play after somebody becomes mentally incapacitated for whatever reason. Maybe they're in a coma, or they were in a car accident, or they can't speak, or there was just moments of uncertainty or things that are unclear with their mental state. But the power of attorney is going to give the individual the opportunity to function and act on their behalf when it comes to financial decisions. Right? So this is one tool. Next, we have something called advanced healthcare directives. So living wills and healthcare proxies are both going to fall under advanced healthcare directives. We're going to put them both in the same category, essentially here. All right. And I'll lump it all together into this category. And what advanced healthcare directives and living wills are the purpose is, again, when you're alive, so you're still living, but you're not able to make decisions for yourself. The power of attorney deals with the financial part of things. The advanced healthcare directives are going to deal with the healthcare part of things. So your healthcare decisions, what type of treatment you're supposed to take place, or you want to take place, how you want certain situations to be dealt with. The advanced healthcare directives are going to provide guidance for whomever to follow those things. And again, you're going to deal with a fiduciary. So you're going to appoint somebody to look out for your best interests in these situations. The living will is a little bit different than the healthcare proxy. The healthcare proxy is going to essentially put somebody in a position where if anything is wrong, you can't make the decisions for yourself. They're going to make the healthcare decisions for you. So they're going to have the power to make all of those decisions on your behalf. The living will is a little bit more detailed. The living will is going to give a plan to whomever that shows this is what I want to happen if these particular things were to happen to me. So the living will is a little bit less control for the individual and a little bit more control for the incapacitated person, because they're making the decisions before they're in that situation. They can be used collectively. And a lot of times what we'll do is we'll put an advanced healthcare directive together. So it's one document that encompasses both of those things in there. Again, this is something that's used while the individual is alive. So you're alive, whoever has the power to act as your fiduciary with either one of these would step up, and they would do that if incapacitation was to happen. All right. Another tool that you can utilize when you're still alive is something called the trust. Now, trust, we're going to talk about trust in more detail later on, but there's a lot of complexities and there's a lot of different versions of trust, and there's tons of questions that always come up whenever I talk about trust. So what we're probably going to end up doing is I'm going to do another session that's just going to deal with only trust. So today I'll just give you an overview so that you can actually engage in a conversation with somebody. You'll understand the fundamental differences between different types of trust. And then next time, when I do this session on trust, I'll get more into the meat and potatoes. This is how particular trusts work. This type of trust is for this. You know, there's tax benefits that are associated with it and whatever those benefits might be. So we'll go over that in more detail later, but just know that they exist. And it's another tool and it's another option that's there for you while you're still alive. All right. Does that make sense to everybody? Thumbs up, a head nod. Okay, cool. All right. Am I going too fast? Am I not going fast enough? No. All right. Okay. So these are tools for you when you're alive. All right. Let's talk about death now. But before we do that, I want to point something out. It's very important to understand that the power of attorney and the healthcare, the advanced healthcare directives, as soon as someone passes away, those documents are no longer, they're no longer good. They pass away with the individual. So they're not enforceable anymore. I've had lots of times where somebody comes to me and says, oh, it's okay. You know, my uncle passed away, but I'm his power of attorney, so I can go do X, Y, Z. You stop being the power of attorney as soon as your uncle passed away. So as soon as somebody passes away, those documents are no longer any good. That's very, very important. We're going to talk about now the documents that you need to circumvent that after death. But first, let's get into some basic definitions. All right. Number one, an estate. An estate is the property of the individual that passed away. So whatever property belonged to that person while they were alive, it's going to pass into the estate. So the estate becomes that person, so to speak. The person is no longer here, so the estate steps up and takes their position. So the estate is what holds their property. The surrogate court. Many of you, if you just voted, you may have voted in elections where you were also voting for a surrogate. Many of you might not have even known what that surrogate was. That's okay. My daughter, who voted today, asked me that question, Dad, what's a surrogate? And I realized that she didn't realize that. Even though I do a lot of work in the surrogate court, I guess I never took the time to explain what that is. So the surrogate court is a separate court that functions in a similar way as our other courts do, but it specifically focuses on a few things. Number one, it's going to focus on death. So when somebody dies, either with a will or without a will, and we're going to talk about both of those and the differences in a second. But when somebody dies, in order to gain access to their estate, in order for there to be somebody legally appointed on the estate, you have to go through the surrogate court. The surrogate court also takes care of things like adoptions and guardianships, and there's a variety of other things that they take care of as well. But all of those things are handled through the surrogate court. And the surrogate courts are set up in the counties in which they operate. So for example, if you lived in Rochester, then you would go to the surrogate court of Monroe County. If you lived in Brooklyn, then you're dealing with the surrogate court of Kings County, so on and so forth. Probate. So this is a term that most people get confused. Probate is the legal acceptance of a will. So whenever you hear the term probate, it's a term that's only associated with wills. If somebody dies with a will, then you're going to go through the probate process. All right. So probate is the association of a will. Some people say I'm going to probate court, and if there's no will, then it's not necessarily probate, it's something else. But probate is the process of legitimizing a will. Decedent. A decedent is the person that passed away. So if you hear the term decedent is the person that's no longer with us. Okay. Executor. So executor and administrator. These are two other terms that a lot of people confuse as well and kind of lump together also. An executor is someone that's appointed to oversee an estate in the probate process. So when there's a will, inside of someone's will, they would name an executor. The executor would act as the fiduciary of the estate, meaning that the executor has to put the estate and everything that's associated with the estate above themselves and act only in the best interest of the estate when they're acting in their capacity as the executor. All right. An administrator. An administrator has the exact same function as an executor, but an administrator comes into play when there is no will. So when there's no will, you're going to have an administrator appointed to oversee the estate. So when there's a will, you go through probate, and then you have an executor appointed to oversee the estate. When there's no will, you're going to have an administrator that petitions the court, and then the administrator is going to be appointed to oversee the estate. Their functions are the same, but how they get there is different. Therefore, there's a different name. Does that make sense? Yes. Yes, we're good. Okay, cool. All right. Again, if I'm going too fast, just let me know. I'll slow down. I only see like 3 people, so I'm counting on you guys. You guys are my guides to let me know if everything is going okay. All right. All right. So let me see here. I'm relying on my handwritten notes because my PowerPoint notes are showing up. All right. So this is death. So let's talk about wills. All right. This is a term that most people are familiar with. So wills are the final wishes of a decedent while they're still alive. So when you're alive, this is, you want to, this is how I want things to be handled when I'm gone. I want such and such to get this. You're going to use a will in order to lay out all your wishes. A lot of times wills are going to be used in conjunction with other estate planning tools. So just because you have a will, that doesn't mean that you can't have a trust, or because you have a trust, it doesn't mean you can't have a will. A lot of times we'll combine a lot of different estate planning tools into one, and they can all be used collectively and used together, depending on what your goals are. Everybody's goals are different. So they're all very individualized. But I'll come back to that. The will is going to specify exactly who gets what, and probably more importantly, who doesn't get anything. That's one of the important factors to have in a will. It's really, really important to understand that just having a will is not enough. So if you decide you want to write your will out in crayon, and you do that, and then you sign it in front of nobody, and you want it to be accepted as a legal will, that's probably not going to be the case, depending on where you're at, depending on the jurisdiction in the states. Most states have a very specific requirement for how a will is supposed to be drafted, and just as importantly, how it's supposed to be executed, meaning how it's supposed to be signed. It's really, really important. I want to stay away from state specifics, but I will say this just as an example. In New York State, for example, if a will is drafted by an attorney, then there's a presumption that it's a valid will. It's a lot harder for somebody to challenge the validity of a will if it's drafted by an attorney. That's one of the requirements. Another requirement is the way that it's executed. So you're supposed to have witnesses that are disinterested, meaning that none of your witnesses should be beneficiaries of the will. Obviously, there could be a conflict of interest there. If there was a beneficiary, there was also a witness, there's room for individuals to potentially act in a nefarious way. They want to try to avoid that. All right. So you're going to want to separate that. So the way it's drafted, hopefully by an attorney, and then the way it's executed are extremely important. They're really, really important. Again, the will is going to name an executor. The executor is going to be the fiduciary that's going to be in charge of taking care of the estate once you're gone. Okay. We're good. Okay, good. All right. Let's see here. So a will, once somebody actually a will could actually be filed with the surrogate court before somebody passes away. So it's not uncommon for somebody to have a will drafted and then file it with the court so that it's on file. I typically, I don't want to say what I would particularly do, but there are reasons why you might not want to do that. A lot of times people end up changing their will. Sometimes you don't want your will on record, or you don't want it to be searchable. But that is an option. So I don't want to misstate and say that you have to wait until somebody passes away before the will is filed. But typically what happens is somebody passes away, the will is taken to the court, and then the individual is going to file to go through the probate process. Okay. So it's filed with the surrogate court. So let's talk about death without a will. Death without a will. somebody dies without a will, that's called dying intestate. Intestate. And if you die intestate, then you have to follow the law of intestacy. See how the two words play together? They're pretty much the same thing, but there's intestate, you die intestate, you die without a will, you have to follow the laws of intestacy. Every state is going to have different intestacy laws. So what I'm going to do here is just kind of give you an overview, an example of how these things work. It's not state specific. Each state is very different, but in general, this is typically how it works. Somebody passes away with a will, the executor is appointed, the executor oversees and makes sure that whatever the wishes were in the will are going to be carried out. Somebody dies with a will, then there's no will to tell everybody how things are supposed to be done. So you have to go through the default law, which is intestacy. All right, so all states are going to file a hierarchy. There's going to be top to bottom down how things are going to flow when somebody passes away without a will. Most states, it's going to be the spouses first. So if the decedent, the person that passed away, if they're married, some states say the spouse takes everything and it stops right there. Other states say, New York, for example, says that the spouse is entitled to the first $50,000 of the estate plus half of the estate. This is if there's going to be other people that fall under this hierarchy, okay? So if there's a spouse and no one else, then the spouse is going to take everything. If there's no spouse, but there's children, then each child is going to step up and take equally. So if there was $100 in the estate and you had one child, then the one child would take the $100. Of course, I'm simplifying because there's taxes and there's fees and other things that have to be dealt with as well. But just so you understand, if there's two children and there's $100, then each would get $50 and so on and so forth. All right. In New York, if there's a spouse and children, the spouse is going to get the first $50,000. They're going to get half, and then the children are going to split the other half. That doesn't mean that the children get 50%. If there's two children, each child will get 25%, and so on and so forth. Does that make sense? Okay. If there's no children, then it's going to go to the parents. If the parents are predeceased, then it will go to the siblings. If there's no siblings, then it's going to go to the grandparents and then the cousins and so on and so forth. So intestacy is going to determine who gets what strictly based on the legal relationship that exists between the decedent and their family. All right. So somebody dies without a will. They died intestate. We're continuing to follow the law of intestacy. The law of intestacy says that we're going to have to appoint an administrator to oversee the estate. Decedent is gone. We need somebody to oversee this process. So in this case, it's going to be an administrator. So the administrator is going to have to file a petition to be appointed, and they're going to file this petition with the surrogate court. It's filed in the surrogate, just like a will. Let me backtrack and just make sure that this is clear. When somebody passes away, the county in which they were living in at the time that they passed away, that's where you're going to file for probate or for the administration filing. Okay, so they pass away if they're living in Rochester, which is Monroe County, then you're going to file it there. That's not that, well, I shouldn't say living there. I should say if they're domiciled there, meaning that's their legal address. If that's the legal address at the time that they pass away, then that's where you're going to file. If somebody is domiciled in Rochester and Monroe County, but they're living in Florida and they pass away while they're visiting somebody, you would still file it in Monroe County. That's where they were domiciled at. All right. So the petition is going to be filed with the surrogate court in the county in which the decedent was living. Again, every state has a different way of doing this. And a different time frame as well. So I can tell you from experience, I do a lot of estate filings and I do a lot of surrogate court litigation in New York City and in the 5 boroughs. Kings County can take a very long time to get through even a simple petition or of administration or a probate filing. Right now, it takes probably 6 to 9 months. That's if there's no litigation. That's just to file the paperwork. What happens after you file the paperwork is that the court is going to either award letters testamentary, which is if for the executor, the letters say that this person has the legal authority to act on behalf of the estate, or they're going to file, or they're going to provide letters of administration for the administrator, saying that the administrator has the same authority to act on behalf of the estate. So the process from the time we file until those letters are issued can take 9 months. I've had it take over 2.5 years before. Again, in New York City, it's a very different ball game. Outside of New York City, the fastest we had a filing done, I think, was in Monroe County, where I got letters of administration in 2 days. So there's a big discrepancy there in how those work. New Jersey is pretty quick as well. It's not on the 2-day track, but it's definitely not on the 9-month track. So there's a strong desire to try to avoid having to go through this process if possible. And that's where trust and other tools are going to come into play. We'll talk about those later on this evening. Okay. In order to become the administrator, you have to qualify. You can't just walk off the street because you heard that, let's say that you heard that Michael Jackson passed away, and he passed away, or better yet, Prince, because I don't know about Michael, but Prince passed without a will. And you want to be the administrator to Prince's estate. That'd be pretty cool. But you just can't walk in and say, I want to be the administrator to Prince's estate. There has to be some type of a family connection. There's a hierarchy process when they're looking at these things. Typically a spouse or a family member, a child, they're going to be given first preference when it comes to an administration situation. There are things that can disqualify you from being able to participate or act as an administrator or an executor. One thing in both New York and New Jersey that's a disqualifying factor is if you're a convicted felon. So even if the will appoints you as the executor, if you've got a felony conviction, it's going to immediately make you ineligible to act as the executor or as the administrator. There's always caveats and there's always carve-outs for exceptions to those things. If your record was sealed, if you got a pardon, there's ways around that sometimes. But for the most part, the consideration is that you're not supposed to have that. Another disqualifying factor could be if you have an active drug addiction or a drug problem, or if you've had one in the past. So there's a variety of things that might push to get you disqualified to become an administrator or an executor. But the job of the administrator or the executor, once you're appointed, is number one, you're going to start to gather all the information. You're going to gather all the bills that are a part of the estate. You're going to gather all the assets that are a part of the estate. You're starting the process of getting everything together. You have to open up a bank account on behalf of the estate, which typically requires getting an EIN number, which is like a social security number for the estate. When it's all said and done, you're going to be responsible for filing the tax returns for the estate. So this is the process of the administrator or the executor, okay? You have to, in this case, when we're talking about intestacy, so somebody dying without a will, you've got to distribute according to the law of intestacy. You can't come in there and say, well, my uncle, I'm going to be my uncle's administrator. You get appointed, and then you say, you know what? I hate my cousin Billy Bob. I always hated Billy Bob. I'm not going to give Billy Bob anything. You can't do that. You have to go and follow what intestacy says. So if intestacy says that Billy Bob is supposed to get 50% of the estate, then you got to make sure that Billy Bob gets 50% of the estate. That's your job. And if you don't do it, you can be held civilly liable and potentially criminally as well. So you have to follow remember, you have a fiduciary responsibility. You have to act above your own self-interest, and you have to do what the law says you're supposed to do. So one of the big myths that I run into is that a lot of times people think that once they're appointed as the executor or the administrator, that they own the estate, that it's theirs now. They can do what they want to do with it. They can take the money. They can go on vacations. That's not the case at all. You have to follow the law, or if there is a will, you have to follow the will and distribute the assets according to the way the will is drafted, or in the case of intestacy, the way that the intestacy law states that you have to do that. Oh, a couple of, well, I think we'll talk about this on the next slide. Let's see here. Okay, Let's talk about some things that pass outside of an estate. So somebody passes away and there's going to be assets that are associated with that estate. There are things that can and should pass outside of the estate. Number one, life insurance policies. So if you have a life insurance policy, as long as you name a beneficiary, and by the way, I'm going to give you kind of like a small checklist when this is all said and done of things that you can do tomorrow immediately for free to help to put yourself in a situation where you're going to start to get your estate in order. The first thing is making sure that your life insurance policies have named beneficiaries. All right. So what is a beneficiary? A beneficiary is exactly what it sounds like. It's the party that's going to benefit from that particular instrument. So in the case of a life insurance policy, the beneficiary is whoever you want to take the policy. You can break policies up in different ways. You might want to say, all right, I want to give, my Uncle Willie Bobo 50%. I want to give my niece 25%. I want to give my other niece 25%. You can do that, and you can put that language into your life insurance policy. So you can tell them how you want the policy to be distributed upon your death. If you don't do that, if you don't designate a beneficiary, the life insurance policy doesn't go away, but it becomes a part of your estate. One of the benefits of having life insurance is that it passes outside of the estate. You don't have to worry about estate taxes. You don't have to worry about going to court. None of that stuff comes into play. So you have the policy. As long as you name your beneficiaries properly, the policy is going to pass and go to those beneficiaries as named in the life insurance policy. All right. So one of the things that you can do tomorrow is check to make sure that you have beneficiaries that are named in your life insurance policies. Things change. Our lives change. Sometimes people are a part of our life today and they might not be there tomorrow. Always check that, periodically. What I would suggest doing is when you do your yearly physical, that you also check on these things and just double check and make sure that everything is still the way that you want it to be. IRAs. IRAs are another thing that can pass outside of the estate. Again, if there's a beneficiary that's designated, the IRA can, and pensions as well, can pass outside of the estate. Okay. Joint bank accounts. Now, I have a little caveat here and it says be careful. Joint bank accounts. If you own a joint bank account with someone else, you pass away, whatever's in that bank account automatically becomes the property of the joint account holder. Okay. The reason that I say be careful here is that there are better ways to designate a bank account to go to somebody if you don't want that person to have control of the bank account during your lifetime. All right. So one way to do it is with a joint bank account. If we're on an account together, we hold it jointly. I'm no longer here. You can do it. What the account is going to become theirs. But also keep in mind that if I put $100,000 into the bank account and the other person puts $10 in, and then tomorrow the other person decides they want to go take $80,000 out of that bank account, even though that's not the agreement that I have with them, they can do that because they have just as much right to whatever's in that account as I do. So one of the ways that you can circumvent that is if you put a POD on your bank account. So if you have a bank account and you want it to go to someone else, you don't have to add them as a joint account holder. What you can do is add a POD, a pay on death. All right. You can walk into your bank tomorrow. Most banks are going to want you to bring the person that's going to be the POD with you so that they can get their information. Not all, but you can call your bank to double check that. But usually what you do is you go in there, you'll say, I want to sign a POD. You sign the POD. During your lifetime, that person can't do anything with that bank account. The POD means nothing until you die. As soon as you pass away, whatever's in that bank account, the person that's the POD, the beneficiary of that, is going to go in there with a copy of your death certificate and they can take the money right out of the bank account. It does not go to the estate. It does not go to anybody else. It belongs to them. So this is something else that you can do tomorrow. You can check on these accounts, or you can add a POD on the bank accounts and distribute them according to whatever your desire is. Okay. Real property. So let's define real property. Real property is real estate, land. The real estate, the real property, you put those together, that's real property. Personal property is anything that's not real property. All right. So when I'm talking about real property and things that can potentially pass outside of the estate, The only way that real property is going to pass outside of your estate is if you deeded it correctly, or if you put it into a trust, or if it's into another, some other form of transfer medium. New York State recently enacted something called the TOD, which is a transfer on death deed. It acts the exact same way as a POD, which is a pay on death with your bank account. You can add somebody as a TOD to your property. They have no legal ownership rights to your property until you pass away. It's revocable, which means that you can change it at any time. If you decide you add Willie Bobo to your deed, and you decide later on that Willie Bobo shouldn't be added there, you can go and take them off. There's no ownership interest unless you die. If you were to die while they were the TOD, then they don't have to do anything. The same thing as the POD. The property automatically goes to them. They automatically take ownership of it. It stays outside of your estate. That's just one way that you can pass property. There's a lot of things that have to be considered when you're doing it. Taxes are a huge consideration when you're trying to transfer real property. And there's other tools that can be used out there as well. But it is possible to pass real property outside of your estate. Trusts. I don't know how I'm doing on time because I don't have my little timer thing. All right, trust. Let's get into some definitions here. Number one, a trustee. A trustee is going to be the fiduciary. The trustee is going to have a fiduciary responsibility to oversee the trust. All right. So the trustee has a fiduciary responsibility to the trust. The executor has a fiduciary responsibility to the estate through the will. The administrator has a fiduciary responsibility to the estate through the administration process. Just vocab refresher here. The grantor or the settlor, that's the person that's creating the trust. All right, so the person that creates the trust and puts something into the trust is the grantor or the settlor. The corpus is the property that's inside of the trust. So whatever the trust holds, that's the trust corpus. So if you hear the term corpus, you know that it's referring to property held in a trust. If you hear grantor or settlor, you know that it's the person that created the trust. If you hear trustee, then you know it's the person that's responsible for overseeing the trust, okay? The beneficiaries, we talked about this already. The beneficiaries are the real owners, and I put that in quotation marks, of the trust. The trust is going to be set up for the benefit of the beneficiaries only, okay? So the grantor is not the owner of the trust. It's really the beneficiaries that own the trust. So there's two main types of trust. There's inter vivos trust, and there's testamentary trust. Inter vivos trust are trusts that are created while someone is alive, and testamentary trust are trusts that are part of a will or part of somebody's estate planning. All right, so somebody passes away, or you're planning for that. Usually a testamentary trust is going to be used in conjunction with a will, okay? The purpose of an inter vivos trust is to avoid probate and, you know, the delays and the cost associated with that. And then it also allows assets to be managed during incapacity if somebody was to be incapacitated. And it also maintains privacy, and it helps to streamline processes as well. There are literally thousands of reasons to utilize a trust, and there's hundreds of different types of trust out there. So I just want you to understand the basic vocabulary around trust tonight. Again, we probably have to take at least another 45-minute session to get into trust, but I want you to have a basic understanding of what a trust is and how it can potentially function in your life. All right. The testamentary trust is used in conjunction with a will. An example of why you would use a testamentary trust would be if you have children that are minors, for example. If you do a will today and you have a child that's a minor, and let's say you have $1 million that you want to pass on to your child that's sitting in an account right now, and your child is 12 years old and you pass away tomorrow, obviously the child is not ready to take the $1 million. First of all, legally, they're not able to do it, number one. And number two, they're going to screw the money up. So you're going to want to set up a testamentary trust, which is going to provide a trustee that's going to give instructions to the trustee on how the minor child is going to take this money eventually over time. So the trustee is kind of be your voice from the grave, so to speak. You can set it up where distributions from the trust can be made when people meet certain milestones. So for example, if you have a child that you want to go to college, listen, if you go to college, you know, your freshman year, you'll get X amount of dollars. Once you graduate, you'll get X amount of dollars. You could set it up for life events, for a wedding, or for a divorce. You could set it up for, you know, the purchase of a home. There's many different ways that you can set up a trust, and there's many different things that can be triggered that would enable your trustee to provide the beneficiary of that trust with access to the funds that are in that trust. You also have revocable trust and irrevocable trust, okay? So revocable trust and irrevocable trust. A revocable trust is created during someone's lifetime, and it can be updated or changed or revoked during the life of the creator, and typically by the creator themselves. So if the grantor creates this trust and they decide later on they want to change it and they're able to do that, that's a revocable trust, all right? They're always going to have the ability to go in and change things and kind of make things function in a different way. Irrevocable trust can't be changed after they're executed. So if you have an irrevocable trust, once it's done and pen goes to paper, that's it. The grantor or the settlor no longer has any control over that trust. There's going to be a trustee that's going to have control over that trust. That's not to say that the grantor or the settlor can't still get benefits from what's inside of that trust. They just don't control it anymore. So a lot of times when people talk about Medicaid protection trust, for example, or MAPs, this is a very common form. What happens in a MAP is real estate or property is transferred into a trust, and then a trustee is appointed. Let's say it's real estate. The individual might still retain a life estate, meaning that they can live in the real estate for the rest of their life, but they don't have any control over the real estate. A trustee is going to control it. And because of that, the IRS and the government says, well, it's not going to be considered an asset. So we're going to remove that from any type of calculations that we're doing to see if you're going to qualify for Medicaid or government benefits or whatever it might be. Okay, so there are definitely timelines that come into play with MAPs and other trusts. I don't want to get into that today, but just know that they're an option and that they are available. And when you're talking about Medicaid planning or special needs planning, it's going to go something that's going to go into an irrevocable trust. Okay, does that make sense? Me, I'm counting on me and Jonathan. I'm counting on you because you're the only ones I can see. All right. So, all right. Okay, good. All right. So let's talk about real estate a little bit here. So I'm gonna just really touch on some things with real estate. The next session that I'm going to do, so I'm planning at least 2 more. The next one is going to be on real estate, and the one after that will be on trust. But I just want to give you some basic understanding of real estate. We already talked about real property versus personal property. We know that real property is anything that's related to real estate. So whether it's land, if it's a house, if it's a condo, that's all real property. Personal property is everything else. Why does real estate matter so much? 90% of all millionaires in this country, their wealth initially came from real estate. And if you think about it from just realistic terms, I actually just had this happen to me for a client of mine. A house was purchased back in the 1960s in Brooklyn. At the time, the house was purchased for $100,000. Now, $100,000 in 1960 was a lot of money, all right? But it was purchased for $100,000 in 1960. The house was just appraised recently for $4.6 million, all right? So there's no other investments. This family doesn't own any stocks. They don't own anything except for this house. And their family has always lived in this house throughout time as well, all right? So that $100,000 investment in 1960 has turned into not only $4.2 million today, but it's also provided shelter for 6 or 7 generations of people as well. So real estate is really important when you're talking about estate planning and when you're talking about trying to build anything for yourself or for the next generation. It's one of the major keys out there, and it's very important. So I want to talk about what everyone should know about buying real estate, selling real estate. On the residential side, there's commercial and there's residential. Residential is real estate that you live in. Commercial is typically real estate that's utilized for business purposes. So I'm just talking about residential right now, but the concepts are pretty much, they're very similar. So the next time I'm going to get into what a deed is, what a mortgage is, what a note is, what a title is, how all those things play together, and why it's important that you understand how those things work. When you buy a house, for example, there's going to be a deed. If you buy a house with someone else, you're going to want to make sure that you understand what the language in that deed means. Sometimes it means that if you die, they take it all, the other person that you own it with. Sometimes it means if you die, it goes to your estate. And sometimes, it can mean that the other person has the right to live there forever until they die, and you can't do anything about it. So you're going to want to make sure that you understand the language of the deed, and you have some final, some basic understanding of that. I'm also going to get into some credit basics as well. Why credit is important, how it works, what the mortgage companies and the lenders are going to look at when you're trying to qualify for lending. But all of the just, again, base level things like what we're talking about tonight. Not, in great detail, but just enough where you start to become more comfortable with the concepts and the vocabulary around real estate and real estate transactions. Okay. Questions. Now, let me just clarify and say a few things before we start with questions. Number one, if the question is more about a personal situation for you yourself, I won't answer that in this forum. You can always call my office, schedule a consult with me. All of my initial consults are free for one reason. I need to figure out if it's a problem that I can actually help somebody with. So I have to get information first to figure out if it's something that I can help with. And I'm not going to charge somebody to get that information. If I can't help them, I can't help them. I'm not going to charge them for that. But if you have general questions about anything that we just talked about, now is your time to fire away. Let me see how much time we have. We've got about a little bit less than 10 minutes, but go for it. Jonathan, I saw that you took your mute off immediately, so I'm assuming that you have a question.
I always have questions, Jason. Thank you very much for having this, first of all. But, I've gone through, personally just some things through the courts and stuff. So my question to you is there you went through this stuff pretty quickly, but is there a way to bypass probate and surrogate court and allow your transfer of everything to go smoothly still?
Yeah, there's many ways to do it. One of the things that we actually touched on a couple of them. You just got to piece them together sometimes. There's the TOD deeds, there's trusts, there's ways that you can appoint certain assets that you own now to somebody while you're still alive. So there's a variety of ways to do it. It's going to depend on what assets you have, first of all, number one. And number two, what your plan is, like what your vision is for how things are going to play out. Once you come up with those answers, then there's tools that enable you to do that. My personal philosophy is a will should be used, for as little as possible. So what I typically, if we do it right, if we're able to do it right, the will should designate things like personal items, like records or photos, things like that don't really have true financial value, but are more sentimental. You want to keep as much out of the courts as possible. None of us like going to court. I'm an attorney. I don't like going to court. So, you want to stay out of courts as much as possible, because the more you're in court, guess who makes the money? The attorneys make the money, right? So you want to stay out of that. But there are lots of tools out there that you can utilize to limit that. As you said, whenever you deal with the system, it can be very frustrating. It can be extremely frustrating. And those frustrations are the person that died, the decedent. It's not their frustrations. They're not here, but it's our frustration. So what we have to do is try to put things in place so that our loved ones don't feel that way when it's our time. So yeah, there are options out there.
Very cool. And I have a second question, if that's okay, regarding deeds. So I recently inherited some property as shared real estate, right? But New York State automatically went ahead and issued the deed. We never even read the deed. Is there something we should be looking for in these deeds? Should we sit down and fine tooth comb and read these? I mean, is this something that just keeps transferring as you go, or is a deed updated by myself or a state or an entity or something?
So whenever a property is transferred, the deed is going to be updated because the deed is what shows ownership in the property. There are defaults. For example, just like we talked about, if you die without a will, the default is the law of intestacy, and there's defaults with deeds as well. So if a deed is silent on how property is owned, then it's going to be tenancy in common. That's just what it says in New York State. And then tenancy in common has different meanings. You know, what happens if somebody dies and so on and so forth. If parties are married and they take the deed, then there's an automatic designation as well. Most people don't know what their deeds say. Most people have an attorney that assists them with the closing and they just trust the attorney. I kind of operate a little differently. I want to educate my clients to the process as I go along because I want them to have as much information as possible. Some clients are like, I don't have time for that. I trust you. Just do it. This is how I want it done. Just do it that way. And I'm fine with that as well. But I would prefer to have an educated client because then we can work more collectively together, try to problem solve and things like that. So hopefully that answered your question.
It did. Thank you. Thank you, sir.
Yeah. Keisha Warren, go for it.
Thank you, Jason. Really appreciate you holding this session. Just a quick question on 401ks and life insurance through your employer. How does all of that play out with what you talked about today with like beneficiaries, trusts, all of that?
Yeah, so what I would do is double check with your employer and ask them what their policy is. So some people, they're all done differently. 401ks are different than life insurance policies. And most, well, not most, but a lot of employers also have like a life insurance policy that's kind of automatically given to employees as well. Double check with them and ask them if there's a beneficiary situation. If there is, you want to designate your beneficiaries now. A couple things to keep in mind. Number one, if you're married, you're going to need your spouse's permission to change any designations when it comes to life insurance or when it comes to IRA benefits or any benefits like that. You're going to need the spouse's permission. That's the first thing. The second thing is you're not going to be able to write your spouse out of those things without their permission as well. All right. So just putting that out there also. Keisha, I'm not picking on you. I'm just putting the general information out there. But double check with your employer and ask them what their policy is, number one. And number two, make sure that your beneficiaries are updated. And whoever you want to take that in the case that you're not with us anymore is going to take those things. Because there's typically options for that within those investment tools.
No, appreciate that. And so if I'm single, I don't need to worry about any of that. And if my beneficiaries are designated, which they are, for those things, 401k, life insurance, accidental death, is there anything else that I would need to do? Or as long as that's designated through my employer, I'm good?
Yeah, for those specific things, as long as those designations are made, then you're good. Remember, if there's no designation, then what would happen is that would go and become a part of the estate. And that's going to force somebody to have to go through the whole estate process if they want to access those funds. So as long as you've designated your beneficiaries, then you're good to go.
Awesome. Thank you.
Welcome. Jessica, you're muted. You got to unmute yourself.
Thank you. You think I would know this by now. Thanks.
Look at me. I'm struggling.
Yes. Thank you again for holding this session. So my question is about power of attorney. So you were explaining that, is that something that we can establish like ahead of time, or is that something that like you deal with as it comes? Like if I want to decide, like I want one of my children to be my power attorney, should something happen to me, I become incapacitated, like, can I do that?
Yeah, you can definitely do that as long as the child that you're going to designate is over the age of 18. So you can have them come in and be the power. You can do that now for sure. You actually, most of this stuff, it's better if you do it while you're in a healthy mind, or where people can, it's more difficult for somebody to challenge your appointment. You know, you might have people that disagree with what you want to do. But if you're starting to show signs of dementia or something like that, you do it at that time. It opens the door for challenges. So it's probably better to do it sooner rather than later.
Okay, and then what does it entail, that process? What would I need to do?
So there are, okay, the power of attorney, the healthcare proxy is probably the most, I don't want to say it's the easiest, but it's the simplest form to do. There's actually a couple of forms that you can find out there. And if you want, I'll send that to everybody. I've got your email, so I can send the form to you so you'll see it. The power of attorney is a little bit more complex because there's designations that you have to make inside the form itself. New York State, for example, has a statutory power of attorney form. So it's going to be the same form that everybody's going to use, but you can change the language and you can do different designations inside the power of attorney itself. My suggestion, of course, am I biased? I'm definitely biased. I'm biased partly because I'm an attorney, but I'm more biased because I litigate these things all the time. And I see where people attack certain things. So I'm always going to tell you that you should consult with an attorney whenever you're talking about type of legal documents. One of the things that I do, most attorneys offer what's called the trilogy, which is a will, the power of attorney, and the healthcare proxy or the healthcare directive. So they kind of bundle them all together and say, you can come and get all these things done for one price. And it's typically pretty affordable. So I would always suggest that you have an attorney that assists with that. It also makes it more difficult for somebody to challenge it down the road as well.
All right, thank you.
You're welcome. Any other questions? Anybody want to type a question because they're just too shy? Keisha, go for it.
Because not shy, so I'm going to ask another question. Executor selection, any recommendations around that? I mean, I get it, you want to make sure it's not someone of a certain age, but like, who's typically considered to be a good executor? Someone that's going to truly, live out your wishes. Like, any thoughts or suggestions to that?
That's a great question. And it's tough to answer. I think that it's going to come down to
All that stuff.
probably understanding. I would pick somebody that's responsible. Number one, somebody that you see is able to pay their own bills and they pay their bills on time. If they say that they're going to do something, they typically follow through, because this is the skill set that's going to be necessary for them to take care of your estate. Things got to be done on time. They have to be able to communicate. They need to be comfortable picking up the phone and talking to people that are outside of their circle. So I would consider all of those things when you're thinking about having somebody take care of your estate. Maybe think about it in this way. If you were to sit back for 3 months and you said, you know what, I just want to disconnect from life for 3 months, or maybe you want to go to an island for 3 months and you got it like that. If that's the case, who would you appoint to handle things so that when you came back here, things would be just as well, just as going as well as they are now? You wouldn't come back and you would be homeless because your mortgage or your rent wasn't paid, and your car would still be there because they paid your car note. So whoever you would appoint in that situation would probably be somebody that you should consider as an executor in your will. It's not always necessarily a family member or a child. You might want to think outside of the box. And actually, one thing to consider is that if you have multiple children, it might be a lot more stress to have one child act as the executor, because now they're going to have to deal with distributing to their siblings. And let's say that the will doesn't distribute equally, and different siblings are supposed to get different things, then that pressure is going to fall on them. So that's a consideration that I would think about as well.
Thank you. That's helpful. Appreciate it.
You're welcome. Any other questions? Hopefully this was helpful. I'm hoping that this was helpful. I do understand that there's a lot of things. I threw a lot of information at you really fast. But I did record it, and I will give you access to the recording as well. I hate to hear myself on recordings. I probably won't listen to it again. But I'll give you all access to the recording so that you can have it if you want to go back and if there's something that you missed. Let me just leave you with a couple of things to think about here. First of all, let me give you my contact, make sure everybody has my contact info, which you all should have anyways, if you got it in the email. So my contact info is here. You can write it down, or you can it's also in the body of my email as well. My email is there, my firm address, and the phone number. If you have any more questions, feel free to call me or shoot me an email. And I don't mind scheduling out some time to talk to you. This is important. I don't want you to feel like if you call me, I'm not going to call them because I'm not ready. I don't have any money yet. No, don't worry about that. Let's just figure out where things are at. And then maybe I can let you, give you some insight into some options that you might have. And then we can, financials and all that stuff is something that will come into play later on. So don't let that discourage you from reaching out to me or reaching out to any attorney. Now you have a language and a basic understanding. So if you want to engage in that conversation with somebody, you can do that. But let me just give you a couple of suggestions here. There's a few things that each one of you should do or can do now. Number one, the PODs on your bank account. You know that you can walk into your bank tomorrow and you can put a POD on your bank account so that if something was to happen to you tomorrow, that bank account is going to go to that individual. So you know that that's an option for you. Number two, actually, Keisha got into this, is you can contact your employer and make sure that all of your beneficiaries are acknowledged properly on whatever forms you have with your employer. Number three, the same thing with life insurance policy. So if you have a life insurance policy, double check it, make sure that there's a beneficiary that's named on there so that you can try to avoid as much of the estate and the probate process or the administration process as possible. So those are things that you all can do tomorrow. They're free. You don't have to pay an attorney to do them. Those are things that you can do on your own. And actually, when somebody comes to me for estate planning, I usually go through this checklist. Did you do this? Do you have this? And I give them homework to do. So these are things that they would have to do anyways. So you can take that and you can run with that. And hopefully there's something, workable that you've taken from this, at least that part, where you can go in and start to implement that immediately. All right. Thank you all for your time. I appreciate you spending the time with me. And again, if you have any questions, everyone's got my contact information. Reach out and I'll be glad to talk to anybody in the future.
Thank you so much. Really appreciate it.
Appreciate you, man. Talk to you later.
Okay.
All right.
Oh, you know what? I apologize. There was some chat that I didn't even see. I apologize. I'm sorry about that. So I'm going to blame it on Jessica because maybe it was her her technology issues that rubbed off on me. No, I'm just messing around.
Okay.
Thanks, everybody.
You.